That's fine. Go ahead.
To break, the defense advised they've got some objections to my exhibit that I intend to introduce with this next witness. Today's exhibit 64 is email exhibit. It's a composite. And I haven't had time to look at all the ones they're objecting to, but I know the first one is marked as State's Exhibit 64A. May I approach?
You may.
This is an email initially from Donna Adelson to Wendy Adelson, and Wendy replied March 28, 2011. It includes content in paragraph 3. There's a discussion of Dan and his parents attempting to spend time with the kids and how annoying that is to Mrs. Adelson. You can read what it says. Defense is objecting to that item. On relevance grounds, relevance is that Mrs. Adelson hated the victim and that hatred extended to his parents as well.
Ms. Fulford?
This is while they're still together, Judge. This is 2011. It has nothing to do with Danny. It was a derogatory comment made by my client regarding Danny's parents. Wendy made comments and Mrs. Adelson made comments, and they're not relevant to this case. This is while Danny and Wendy are still together.
As to whether your client had any animus towards the deceased, is there a time period where it has to be within the divorce?
It's not animus towards the deceased. I'm talking about her comments towards his parents.
Kappelman, as it relates to the comments going towards the parents.
I think it's relevant, Judge. Goes toward motive. She did not want these children to be with the father and with the father's family. She wanted them with her and her family. And that's what happened.
That's not what this email says.
Right. That's not what the email said. It's not a confession to murder. It's a expression of dislike, which just goes to the motive.
All right. Much of this email does lack relevance or probative value for the jury. However, Ms. Kappelman, does this tie into other messages which otherwise would demonstrate the motive you're trying to prove? Or is this a standalone item?
I mean, there are other emails that express similar sentiments. I don't think they're specifically tied to the visit that's referenced in that particular email.
Are you arguing then that the defendant had a consistent animus towards the deceased?
Oh, yes.
Very well. Over objection, I will permit it only on the grounds that it shows that the defendant had a consistent animus towards the deceased or his family. However, if the defense is asking for a limiting instruction As to this evidence, you may request it now.
Can you repeat the email?
If we're asking, yes, we would ask for limiting instruction. This is not directed towards Danny Markel. I mean, if you take a look at it, Mrs. Adelson is complaining that Danny and Wendy have to schlep the boys down to see his parents instead of them driving up to see the boys. It has nothing to do with trying to keep the boys from the family. So I'm not sure what limiting instruction would be effective, but this is as to, it doesn't express any animus to Danny. So I'm not sure what the court would suggest.
Or his family.
The state's theory is not hatred towards Danny Markel's family. And so I'm
Ms. Kaplan,
confused.
as to the state's theory, please clarify this issue.
State's theory includes that Mrs. Adelson hated all things Dan Markel, and all things Dan Markel needed to be erased from these children's lives, including the grandparents. Now, I know Your Honor has precluded me from mentioning visitation with the grandparents and things like that, but obviously that's always been a part of the state's theory. I understand that I'm limited from including that, but it is important to show that this animus existed as far back as 3/28 of 11. And this is the first item in the exhibit because it goes back the furthest in time. I think it's important.
We're not going to be wasting a lot of time on this back and forth. This is the point of pretrial motions. On this point, as it relates to the state's theory of the case, that the defendant had animus towards the deceased or his family, it will be permitted on those grounds. If the defense is asking in some way for a limiting instruction to be given, please request it now.
Yes, Your Honor.
What is the limiting instruction that is requested?
Your Honor, I'm at a loss. I think that an instruction that, I mean, this doesn't show hatred towards Danny. So again, I'm not sure. Obviously I disagree with the state's argument concerning this. So I'm open to suggestions.
Be considered for the defendant's state of mind as it related to the deceased or his family.
I would ask that it be related to the deceased's family, because it's not to do with the deceased.
Ms. Kaplan. Very well. Down.
There's 5 more items, Judge.
Let's go through them.
Yes, sir. State's Exhibit 64D is an email dated 10/26/12. May I approach?
You may.
This email is from Donna Adelson to Wendy Adelson, showing her a list of prospective love interests from the website that Mrs. Adelson has identified as potential matches for Wendy. It's offered to show how controlling Donna Adelson was over her children's lives, how much she inserted herself into their private lives. And again, she likes to be in control of who they date and who they marry.
Response.
Judge, this is not an email from my client to Wendy Adelson. This is an email from Match.com to the email address that my client has. It doesn't say anything, the copy I have at least, doesn't say anything at all about Wendy Adelson.
Okay, I'll replace it with a copy that shows the email heading on the top, Judge. It's my fault.
And this was her forwarding this or actually including some sort of message?
She forwards it. I'm not sure if she included a message. She definitely did on the next one, which is also subject to Defense objection, it's State's Exhibit 64I. I'll approach with that as well. Related.
What's the date on that?
What's the date on that, Ms. Kaplan?
1/17/13 is the date on Exhibit 64I.
All right. As to any questioning of Wendy Adelson as the role her mother played in her life, including screening potential romantic interest, that question certainly can be asked, but as to an exception to hearsay, what is being offered concerning this?
The relevance of it, or
Yeah.
the exception to hearsay is it's
Let's
a
go
statement
through
of a
both.
party. Relevance is that Mrs. Adelson was very controlling and micromanaging in her children's lives, particularly in their love lives, which directly relates to the motive to this offense.
Right.
Eliminated Mr. Markel. You get it, you get the idea.
I just can't understand how this would be material to this case in any way, anything that the state has to prove. That, you know, it's not, we just want to bash her reputation or what she did. They got to prove criminal offenses against her. How does her being on Match.com while she's living with her daughter have anything to do with something the state has to prove here? Nothing.
I believe this once again goes to the issue of motive. I understand the defense's position that you disagree. As to this motion, or excuse me, as to this item, this is you said 64I.
64D and I, Your Honor.
Right. As to whether the defendant in any way possessed a motive concerning Wendy Adelson, or excuse me, as it related to the deceased in controlling who Wendy Adelson may have sought as a romantic interest. Ms. Kappelman, do you have other evidence that's going to tie that to this particular item?
I do have other evidence that Mrs. Adelson, she's on the wire speaking about Wendy's love life and her current love interest and who she wants her to date, and discussing with Charlie Adelson, wanting Charlie to intervene with Wendy and encourage her to date a certain person. So I do think it is a theme that reemerges with other evidence.
Well, as the state of mind and motive, I will permit this evidence to be given over objection. However, as to the foundations for these things, Ms. Kappelman, they'll have to be laid through the appropriate witnesses.
Okay, all these items came from a search warrant executed on Wendy Adelson's Google account. The next item, Judge, is, just a moment to locate this. I believe it's 64W, an email dated June 27th of 13. And the objection in this case relates to the characterization of Judge Hobbs as a, can't find the quote, but something like a Southern black lady. They just were proposing redacting that. Find the page for Your Honor. It's redacted, so. It's page 2 of that email. I'll give you 1 and 2. Second page, 2/3 of the way down in the second paragraph, mentions characterization of Judge Hobbs. There's no particular relevance to that characterization of Judge Hobbs, so I just don't think it's prejudicial, so I don't know why we're redacting. Whatever Your Honor thinks on that one, Judge.
Folks,
I believe the jury could take that as in a very derogatory way. It has absolutely nothing to do with this case, that comment. Nothing. Unless there's another motive I don't know about.
if in some way, since we do have 2 jurors of African American descent that would otherwise impute on the defendant a negative character trait, I will permit the redaction for that reason. Beyond that, the item will be admitted.
Next, Judge, is an email dated April 7th, 2015. I believe what's referenced here is 64HH. Yes, sir. May I approach?
You may.
May I have the other exhibit? Judge, this email is an email regarding Wendy moving, and the evidence is going to show that she moved from a more secure location to a less secure location, so the relevance is sort of going to have to be developed as the trial goes on, but the idea is that there was no fear for Wendy's safety.
What's the date?
That email is dated,
7/15, I believe, is the last date in the chain.
thank you.
If you have to start the foundation with one witness but enter at a later point, that is certainly appropriate. What is the objection?
Well, Judge, I have a question. The email that I'm looking at that was provided to us on July the 15th, 2014 is to Jeff Lacoste from Wendy Adelson.
I believe these are from David Trafton at MiamiRealEstate.com.
That's not what we were given.
May I show the exhibit to the defense?
Please do.
Email that we've been handed is April 7th, 2015, 4:42 p.m. This is regarding Wendy moving. It had the same security as where she was living with her mother, so less secure. There's nothing in here that indicates that.
Ms. Cunningham.
I'm going to ask Ms. Adelson about that. My understanding is it is less secure. They're asking lots of questions, but they're not about security, which if they're being actively extorted under threat for their lives, one would expect and would inquire about such a thing.
You may lay the foundation, or at least begin to lay the foundation for that item with when that witness is examined. Going back to the last trial in this matter, when the intent instruction was given, the intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in the case. Specifically, as counts 2 and count 1 that are charged in the indictment deal with aspects of intent. I'm going to find evidence that demonstrates the defendant's alleged motive, which goes specifically to intent, is admissible. One thing, though, that is starting to trouble me with those. We had many motion hearings in this matter, and we've continued this case several times to handle these matters pre-trial. Why is this coming up now?
The exhibit that we were provided with, I went through thoroughly and had all of my objections listed. And then was told that's not correct. It's another binder. It's different emails. The binder I was handed by the state was completely discombobulated, not in date order. It was a train wreck.
As the state's exhibits you're referring to.
That's correct. And so then they provided us with this binder. It appears to maybe still be missing something, but they have a list, an exhibit list, everything laid out by date, by exhibit A, all the sub-exhibit numbers. So that's why, Your Honor.
We're not going to be wasting the jurors' times. At this point, we're 30 minutes behind where we should have been. Are there any other matters that need to be addressed?
There's one more that I asked for, Judge. It's dated April the 20th of 2016, and it's an email about whether one of the children is sad.
64II, Judge, is an email specifically in which the defendant is claiming that the child cannot be sad about the death of his father. Extremely relevant.
Probative value is outweighed by the undue prejudice, Your Honor.
Compliment again, the purpose this is being offered for is going to motive or state of mind.
Yes, Your Honor.
What is the undue prejudice that the defense is arguing concerning this particular email?
The undue prejudice is what the state is arguing, and they're going to argue to the jury, is that this email says that Donna Adelson said he could not be sad about his father. What she's describing is her time with the child, and she hasn't seen him sad. And it's 2 years after, unfortunately, Mr. Markel was killed.
Ms. Kettleman, if you wish to proffer the testimony from the witness on this, I'll allow you to do so in the presence of the jury, but this one is seeming a bit attenuated.
That Mrs. Adelson.
In commenting on how the child is sad.
Sure, Judge, but it relates back to the motive and thinking that it wouldn't harm the children. It was going to be good for the children to get rid of their father. Children have no memory prior to this young age that the father was killed. think it goes to motive, Judge.
That, I'll allow you to set up your foundation within parts if you need to do so. I'll revisit whether this item can be admitted at that point.
Alright, sir, there's one item that I've added today in light of the opening statement regarding Mrs. Adelson's use of the Skype to facilitate visitation with the father. It's dated December 18th, 2013. It has been previously provided. It's now marked as State's Exhibit AA.1. While the defense is looking that over, I also have a stipulation of the parties may I approach.
You may.
This will be the first thing. I'd like to have your honor read this to the jury as soon as they come back in. Sorry, Judge, I've handed them the wrong thing. I'm gonna have to circle back to that. With that, stipulation, we're ready. No other issues.
All right, as to 64, I believe D and I did rule over motion that these can be admitted with a proper foundation. As to I believe that's the item that the state is going to, 64II, I should say, that's the item the state is going to attempt to lay the foundation for as it relates to motive in this matter.
Yes, sir, I found the relevant portion. It reads from Donna to Wendy here. I'm sorry, from Wendy to Donna. Dear Mom and Dad, here is the phone/Skype plan for the holidays. And she's forwarding a Skype plan from Dan Markel. Please help me do this. It means less stress for me if we just follow it.
I don't know what the relevance of that is. Wendy Adelson sending an email to her mother because her mother takes care of the children very frequently and saying, here's the schedule, let's do this. It doesn't say Mrs. Adelson has not done it.
I think it suggests that Mrs. Adelson has not done it, or at least that there's been issues and problems with Skype and facilitating Skype is satisfactory to Mr. Markel. So I would ask to admit it based on the statements made in opening statement by the defense.
Well, the opening statement is not evidence. The jurors are not considered as such. As to any foundation that you wish to lay for that particular item, that it was not previously followed, and now Wendy Adelson sent that item to her mother, you'll need to establish the foundation first before it's offered. Please bring in the jurors. And I are offered, the limited instruction will be given.
Thank you, Your Honor.
All rise, jury, enter the courtroom.
Everyone can be seated. Members of the jury, I trust you had a restful lunch break. Before we resume with the evidence this afternoon, I'm going to read to you a stipulation that has been agreed upon by the parties. When the parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is the projectiles contained in State's Exhibits 122 and 123 were examined microscopically by a firearms expert from the Florida Department of Law Enforcement and were determined to have been fired from the same revolver.